Yes, Mr. Kessler.
My Lord, I appear for Mr. Bone. My friend Mr. Trivedi appears for Mr. Williamson, who is a High Court Enforcement Officer. I'll call an HCEO. This appeal is about who should be a respondent to an application to CPR Part 84, Rule 84.16. There's a dispute about the amount of fees recoverable under the taking control of goods fees regulations. 14, I'll call those fees regulations. Mr. Bone's case is that can be the HCO, and I believe he enjoys the support of the intervention of the High Court Enforcement Officers Association. I'm going to call the association. Mr. Williamson's case is that the only respondent to such an application can be the enforcement agent. This appeal raises two wider and fundamental questions. The first is about the role of an HCO. I say an HCO is potentially liable for every aspect of the enforcement of a High Court writ in their name. That the named individual, commanded by writ, to enforce a specific judgment. They can appoint whichever enforcement agent they choose, but they remain liable. That is what the debtor pays them to do. Again, I say I'm supported by the intervention of the association and also its public statement of best practice. Now, Mr. Williamson not only denies being liable for the errors made in the calculation of fees, such that he shouldn't be a respondent to a fees assessment, he also, via the respondent's notice, denies liability for any damages suffered by the debtor resulting from the invalidity of the writ or from a breach of the Schedule 12 procedure. Now, clearly Mr. Williamson takes a different approach to his responsibilities than the association does. And the second fundamental question is this: what should an HCO do when they disagree with the association about the scope of their duties? I say the proper approach would have been to apply to the court as its officer for directions. And instead, what Mr. Williamson has done is unilaterally conclude the 2007 Tribunals Courts Enforcement Act, I'll call the 2007 Act, relieves him of responsibility. He's ignored the association's statement of best practice, and he's waited for a debtor to sue him. And given that judgment debtors are among the most vulnerable members of our society, with the least access to legal remedies, the most reliant on an officer of the court being an upstanding and responsible individual, my position is that is the wrong approach.
Where does that, how do we deal with that
in the question
in these proceedings?
Costs. This ultimately, my Lord, is about the costs. I say that Master Sullivan reached the wrong decision on costs because she held that Mr. Williamson should never have been joined. And then I'll.
But if she was right about that as a matter of interpretation of the regulations, and you say that she should still have awarded costs because he didn't adopt the right procedure as regards the association?
No, I don't think I can say that. I think that goes beyond the scope of this appeal.
So where does that come in then?
So it comes in because I'm going to invite the court to quash the decision of Master Sullivan on costs on the grounds that Mr. Sullivan was the right respondent. And then this court, I'm going to invite this court to determine the question of costs. And I'm going to say that notwithstanding there were unsuccessful elements of Mr. Bone's application in respect of damages, the proper cost award given Mr. Williamson's conduct is that all the costs be awarded to Mr. Bone. That's where it feeds in.
I see, thank you.
One last point on this subject is that the court to know that there are 46 High Court enforcement officers. There's actually a complete list in Volume 2 of the White Book. And that means that this is part of a wider matter. Approximately 1 in 46 High Court writs have been and are being supervised by a man whose stated position is that at least since the 2014 reforms, he is not responsible for their enforcement. The structure of my submissions will be as follows. I'm going to begin with about 10 minutes of background to enforcement by way of taking control of goods in the abstract. I'm then going to spend a little more than an hour on ground one, beginning with an overview of the 2003 Courts Act, the 2007 Act, and the various schedules and regulations. I'm then going to make 4 arguments as to why an HCO can be a respondent to such an application for a fees assessment. The 4 arguments are, firstly, because an HCO is the legal owner of the proceeds of recovery, and they must therefore be a respondent to the application because they may be ordered to return funds to the debtor. The second argument is that on a true construction of the statute, an HCO is an enforcement agent within the meaning of the fees regulations, and you shouldn't distinguish between them. My third argument relates to paragraph 66 of Schedule 12. It's going to be that because taking control of goods more than the amount outstanding and the fees due, that itself is a breach of Schedule 12, for which an HCO is liable. And the fees assessment is really the second side of the same coin. It is, if the wrong fee is retained, there has been a breach of Schedule 12. And my fourth and final argument will be as an instance of the general law of agency and vicarious liability, which I will argue has not been excluded by the 2014 reforms. I'm then going to make some concluding observations, including discussing the intervention from the association. And finally, I plan to discuss the application of the law to this case, which, as we've been discussing, relates to the correct cost order made by Master Sullivan. If Master Sullivan was wrong about joinder, then I will invite the court to quash that and award cost to Mr. Byrne. I intend to finish at least half an hour before lunch. So beginning with just some background to taking control of goods legislation, just begin with a few observations. The first is that it's an extraordinary power. It allows the enforcement authorities, which is the word I'm going to use to refer to both the enforcement agent and the HCO, the enforcement authorities, gives them powers to do things which, if anyone else in the world performed them, even the judgment creditor, it would be a crime. They're entitled to enter and remain in houses without consent. There's no ability to sue for trespass. They're entitled to take whatever property they see fit, with limited exceptions, without consent. There's no ability to sue for conversion. And unless there is some defect in the writ, or there is a breach of Schedule 12, we will see that there are limitations on the debtor's remedies in the common law. Now, this obvious infringement of the debtor's human rights, Article 8, A1, P1, this is completely justified by the need for court orders to be obeyed, and this is ultimately about enforcement of the court order to pay a certain sum of money. But the exercise of these extraordinary powers is meant to be tightly regulated, principally by Schedule 12 and the associated regulations. There is a power disparity between the debtor and the enforcement authorities, and there are several elements of this inequality. Firstly, in support of these radical powers to enter someone else's home, take possession of their property, Section 10 of the Criminal Law Act provides it's an offence to interfere with an enforcement officer or any person who is engaged in enforcing the writ. Not only is it an offence for which the enforcement officer, the HCO, and probably the enforcement agent can themselves arrest the debtor for. Secondly, debtors are likely to be poor. I don't say so simply because they have an unpaid judgment debt and so they're insolvent on a cash flow basis, but also because of the means of enforcement. If a debtor has a house, it's easier to obtain a charging order. That would provide security in the interim while the judgment accrues interest. If the debtor has cash in a bank account, it's easier to get a third-party debt order, get immediate payment. If the debtor has a job, then the judgment creditor can get an attachment of earnings order. Taking control of good means realising value from second-hand chattel. And not only is the chattel unlikely to have much resale value, but much of the value is likely to be lost through auction fees, valuation fees, and of course the costs of the enforcement authorities.
Can I just remind you, Mr. Kess, that we have read your submissions in great detail, and particularly with these general introductory remarks, which come as no surprise to anybody. And one other thing I would say is I think we can probably provide you with a glass as well if you'd like one.
I think I have one here. Thank you.
So, by all means, don't want to take you out of your course, but I think going through quite painstakingly what's in your skeleton, I don't think is going to help us a great deal. Maybe we want to get into the nitty-gritty of it sooner rather than later, maybe.
If I may, I would like to persevere because I have a few observations about this inequality, but I do take...
Well, I don't think this court it's any great news that there is inequality in the positions, and it's all being dealt with through the legislation and the regulations. With that in mind, I think what we really got to get to is the core of it, haven't we? And I don't think we need to be convinced that the persons who are being the subject of the execution of an enforcement writ are likely to be in an inferior bargaining position to those who are enforcing it.
So I'm grateful for that. One of the reasons I I do want to delve into this is because there's, in my respectful submission, a mistake in Mr. Justice Lambert's judgment when it comes to this. Mr. Justice Lambert refers to there being no evidence that Mr. Williamson was in receipt of the funds. And that partly arose from misunderstanding the landscape of enforcement, which is that you have these private individuals. I haven't yet got there, that's my very next point. These private individuals whose only source of funds as permitted by the TCA regulations is through the fees regulations. And the point I wanted to make, and perhaps I can make it this briefly, is that you have a mixture of enormous power, but also private incentives. And as I plan to explain, the protection a debtor has in these circumstances is the protection of the role of the High Court Enforcement Officer, an officer of the court hand-selected by the Lord Chancellor, a man who can be trusted to play by the rules. But more than that, trusted to act fairly and honestly at all times. Because the only way in which a just system of enforcement can operate is if the enforcement officers get it right the first time. The court must construe the legislation. We'll come to very shortly with that in mind. But I take your Lordship's point, and I propose to move ahead then, with the risk of needing to repeat myself later on, but that's fine, to the TCEA, second part of my submissions. And it's going to be structured as follows. I'm first going to set out, in general, the Courts Act, Schedule 7, and the HCA Regulations 2004. And then on the other hand, I shall set out the 2007 Act, Schedule 12, and the fees regulations. I'm going to do this at quite a high level, just so all the pieces are on the table, and then I'm going to make my 4 arguments, and that will be my structure. So let's begin with the Courts Act 2003. That's at tab 7. I find just a quick canter through the key provisions, such that when I next refer to it in the course of my arguments, it'll be clearer to the court how they fit in. Beginning with section 1, the general duty of the Lord Chancellor to ensure an efficient and effective system, support the business of the courts. And in order to discharge that duty, section 2 provides, subsection 1, that he may appoint such officers when other staff as appear to him to be appropriate. Over the page is section 99. I only mention this because it introduces Schedule 7, which contains provisions about how court gets of execution. And over the page again, looking quickly at Schedule 7, there are 2 specific paragraphs that we will refer to in the course of this appeal. First is paragraph 2, which provides the authorization of an individual by the Lord Chancellor, someone to become an HCO. And the second is paragraph 7, which tells us what an HCO actually is. Some features to observe in paragraph 4. First is possibly easier to start with subparagraph 2, which provides that the relevant officer has, in relation to the writ, the duties, powers, rights, and privileges and liabilities that sheriff of the county would have. It's because of this provision that we will need to look, unfortunately, at some of the earlier case law to find out what those liabilities are. But it is subject to Schedule 12, as you can see from paragraph 1a. And one of the questions this appeal is going to be, what are the limitations imposed by Schedule 12? So just quickly, very quickly, because the point is a simple one, paragraph 12 on page 39 provides the provision of regulations. Lord Chancellor may make regulations. So, and it's under paragraph 12 that the HCO regulations were enforced. If the court is with me, I'd look quickly at the HCO regulations, just again highlight the ones which I'm going to refer to again in their order. The most important for my purposes is going to be Regulation 8, conditions to be satisfied following authorization, which sets out continuing duty on all HCOs do 5 things. The most important for my purposes is D, or the bank account through which money is recovered on behalf of the judgment debtors to be collected and paid. And my first argument is going to say that that therefore means that the HCO is the legal owner.
Mr. Kessler, you're galloping on at a huge
Yes.
speed, and some of us have to take a note.
Apologies.
So you were looking at Regulation 8.
Yes, I didn't mean to make...
Paragraph D, yes?
Yes, I will return to this. What I plan to do is show the court a suite of legislation and then go back and say this is how it fits together. At the moment, as I see it, my lady, I'm just putting the pieces on the table. I'm not yet rearranging them.
Mm-hmm.
So just to be clear, monies recovered by an enforcement agent are paid into the bank account of the HCEO.
Well, they ought to be, in compliance with this regulation, my lord, yes. Now, there's some evidence that Mr. Williamson is not compliant with that, but that's a matter of fact. As a matter of law, I say the effect of 8D is that, yes, all monies recovered, and we'll see what the word recovered means shortly, are to be placed into this bank account in the name of the HCO.
The wording recovered on behalf of judgment debtors
Yes,
is slightly oddly worded.
it is indeed, my lord, because it's not doing the judgment debtor any favours by recovering.
But it means that it's effectively their money it's recovered from them by way of payment towards their debt or whatever, in that sense.
In that sense, yes, that's exactly. I mean, I think it's very difficult to construe it any other way. It's conceivable that there should be a special debtor-specific bank account after the sales process into which monies go, and then it goes to the debtor. Surplus of enforcement goes to the debtor. But I think that's a very strange reading. I invite the court to reject it. I can make more submissions on it if it's something my learned friend wants to raise. I think the simple reading of this is the enforcement agent comes in, they take goods, they sell them. We're going to see that in Schedule 12. Where does the money go? It goes to the bank account in the name of the HCO. And so, I do appreciate the pace is quick, but I will return to the important provisions. I'd like to move on to the 2007 Act, tab 9. So, Section 62 effectively mandates the use of Schedule 12, where an enactment provisional warrant confers the power to use the procedure in that schedule, taking control of this procedure. There are actually some exceptions that they don't matter. I'd be surprised if there are very many. They relate to ecclesiastical writs and certain court authorities. But your standard county court, high court judgment will go through this process as a result of Section 62. And Section 63 is about enforcement agents. We are going to return to this again in some detail. But there are restrictions on who can act as an enforcement agent. Essentially, it's either someone with a certificate or someone exempt. And I'm going to argue, I don't plan to do it right now, but I'm going to argue shortly that an HCO is an exempt enforcement agent. Moving on to Section 65, if I may. Section 65 is a slightly odd section. So the common laws are replaced about the exercise of powers under which it becomes the powers to use the procedure. It specifies 4 specific rules that are certainly replaced. But the scope of what else is replaced, if anything, is a little uncertain, although it is limited to the rules about the exercise of powers. And there is some, I think there is some dispute between me and my own friend about the scope of Section 65. But I'll come on to that shortly. And lastly, whilst within the Act, before going to Schedule 12, is a general power to make regulations in Section 90. I don't think the court needs to spend much time on it, but that's how regulations are made under the 2007 Act. So, if I may, I'd like to move on to the Schedule 12, which is the workhorse of taking control of goods of the 2007 Act, beginning with paragraph 1. Paragraph 1 is very important because it contains a definition of what it means to recover a sum. It's a recursive definition. It's slightly unhappy, but to recover a sum means taking control of goods and selling them to recover. Sorry.
Be kind enough to tell us where we find it.
I apologise. Page 61, standard type 9.
Yes, thank you.
And it's the definition of to recover a sum, is to take control of goods and sell them. I will argue that the proceeds of such a sale must go into the bank account of the HCO. But it is important to bear in mind that when the Act in the Schedule 12 refers to recovering some, it does just mean taking control of goods and selling them. Paragraph 2 over the page, Schedule 12, is another critical paragraph I'm going to return to actually twice. But first, in the course of my second argument, we'll see what Lord Legate said about it in CS and Marston. And it also features in my fourth argument about common law liability. And this point was in my Skirton argument, I don't want to repeat it, but the court might have seen that there was some hesitation in the order of Lord Justice Warby when granting permission to appeal about whether it was indeed true that an enforcement agent was only had to act under the authorization of an HCOA. And you can see that in subparagraph 3. Sorry, subparagraph 3, yes.
Well, the writ is directed to the enforcement officer.
Yes.
And it is he who is commanded to seize the goods.
Yes.
And the only fees which he is entitled to raise are those to which he is entitled.
Yes.
So everything, not surprisingly, the enforcement agent is doing must come under that rubric as agent for the officer.
Well,
that's the only way it can work.
I completely agree with you, my lord. But Mr. Justice Lambert didn't see it that way.
No,
but yes,
yes.
Your
that's your appeal.
That is the fourth argument I'm making.
Yes.
Yes.
That's your argument.
Yes, it's not my only argument, but it's one of them.
No.
So it may be my best argument, but I do have more. Paragraph 3, if I may, Schedule 12, just the two flagged definitions. Amount outstanding is going to be defined in paragraph 50. We'll come to that very shortly. But also the definition of a good, which is a very broad definition. Property of any description other than land. And that sometimes matters, because if you consider taking control of money, you might wonder whether money was a good, and the answer is it is under this definition. If I may move on to paragraph 12, This is on page 66. This is about excessive enforcement. Maybe I should pause and let the court read it. The reason it matters is I'm going to argue, and I will come back to it, that it is breached in the case of a fees dispute because the enforcement agent would have taken control of more than the amount of expected future costs, but we will come back to it.
Or future costs, or the amount outstanding presumably includes not just the judgment debt, but any fees that have already been incurred.
Yes, we'll have to come to paragraph 15 for a definition, but I do agree with that.
Well, otherwise it wouldn't make sense.
Yes. The point will be that where there's a dispute about fees, then the argument is that too much has been taken.
Yes.
Under paragraph 12. But I will come back to it. I do want to have a complete picture and then to zoom in. If I may, I'd move ahead to paragraph 50, which is this definition.
So just pausing there, Mr. President. So subparagraph 3 of schedule paragraph 12 says for purposes of this paragraph, goods are above a bidding value only if it is or ought to be clear to the enforcement agent that they are.
Exactly. Yes. So an example might be enforcement agent walks into a house, sees a vase. It may be a Ming vase of tremendous value. It may just be an ordinary vase from Tesco's.
Yeah, so he doesn't know.
So he doesn't know.
And it doesn't have a label saying this is a Ming vase worth £50,000.
Exactly.
Yeah.
Exactly. So he can still take, it wouldn't necessarily be a breach, wouldn't be a breach.
No.
To take control of that good, even though it might eclipse the entire value of the debt. And then
In other words, he doesn't have strict liability for failures to appreciate the true value of the goods.
yes,
Yeah.
exactly. And we'll come on to this claim that you're alluding to under paragraph 66 very shortly. But I agree. And before we get there, on paragraph 50, the application of the proceeds. Firstly, it contains the definition of the amount outstanding. So paragraph 3. As my Lady Justice Andrews has said, that includes historic amounts recoverable costs. And if the proceeds are more than the amount outstanding, the surplus must be paid to the debtor.
This paragraph seems to be addressing how the proceeds are to be dealt with.
Yes.
And it appears to be anticipating that they will be dispersed by the agent.
Yes.
Not by the officer.
Well, we'll see what Lord Legate says about that in the course of my second argument. But subject to that, yes. Moving on briefly to paragraph 62, which I only mentioned because it's the paragraph of the Treasury 12 that introduces the fees regulations. It just provides that regulations may make provision for recovery by any person from the debtor in respect of costs of making services. I think that paragraph is contentious.
It's interesting because the power to make regulations is a power that would enable regulation to be made, making provision for the recovery by any person from the debtor of the amount stated.
Yes.
But in fact, the regulations, well, on a naive reading, appear only to make provision for the recovery by an enforcement agent.
That's an interesting observation, my lady. And now I'll move on to paragraph 66, which is contentious, and it's one to which we will return to more than once. And it is provision for debtors to seek remedies for breach of provision of the schedule, or for acting for an enforcement agent breach of provision of the schedule, or acting under enforcement power under a writ which is defective. A few points to draw to the court's attention. So paragraph 2, a breach and defect can never make enforcement agent a trespasser. 3 and 4 permit proceedings to be brought, and 4 specifies where the proceedings are brought. Subparagraph 5 deals with the relief that may be sought. 5A is preparatory relief, give the goods back. 5B is damages. And the point to which we return is the related party point, defined in subparagraph 6. I'm going to argue that an HCO is a related party, and my learned friend disagrees by way of respondent's notice.
It's a little difficult to see how 6A can mean anything other than the HCEO.
How 6? Well, I agree, and so does Mr. Justice Lambert, but the point is taken in the respondent's notice.
But there's a further point arising potentially from paragraph 66, which is that where the draftsman intends to bring in, potentially to bring in somebody else, and in particular the HCEO,
Yes.
there's a specific reference to that person. So 66.2, breach or defect does not make the enforcement agent or any person he is acting for a trespasser. And then the reference to a related party in 5B, related party being defined in 6.
Yes.
So that suggests, well, what do you think? Does that suggest that where the regulations mean to apply to the HCEO, they say so specifically?
So I don't agree, and we'll see that I say Lord Leggett would disagree as well. And that's basically because it is very likely, it's not necessarily happening so, it's very likely an HCO will instruct another enforcement agent to do the work, be the one actually physically at the house taking control of goods. And you may have thought that it would just be the man on the job who breaches, who might commit some tort, who's liable. And so there are times in which it's helpful to distinguish between specifically the person whom enforcement power is conferred, even if they are nonetheless also an enforcement agent, they're not the one there. But perhaps that was too cryptic, and I should come back to it. And see what Lord Leggett says.
Yes, because at the moment
I do place weight on it.
At the moment I'm not entirely following that, but yes.
I understand why not, and I apologise.
All right.
This is a labyrinth. This is one of the points I was going to make in opening, that there's a spider's web of legislation that's very difficult to fight through. It's yet another reason why a debtor would struggle to seek access to justice.
All right, well, let's see what Lord, in due course, when it's convenient, what Lord Leggett had to say about it.
if I can quickly look at the fees regulations, just to complete my overview. This is in tab 11, page 110. Beginning with the preamble, just for completeness. So we know how the regulations are made. And the most important regulation is Regulation 4. Page 114. And it says the enforcement agent may recover from the debtor the fees indicated in the schedule. As I understand the argument, the reasoning of Mrs. Lambert, she places great emphasis on the fact that the enforcement agent may recover enforcement agent. Although we have seen already, and I will come back to it, the word recover is a term of art, meaning take control of itself.
But who else can recover those fees from the debtor?
So the enforcement agent can take control of them and sell them. But if fees go into the bank account, they would no longer be fees legally belonging to the enforcement agent. They'll be in someone else's bank account, namely the HCO's.
Just pausing there.
Please.
4.1. The enforcement agent may take control and sell the fees indicated in the schedule. That makes no sense at all.
Well, it's take control of goods for the purposes of recovering the fees indicated in the
Yes.
schedule. So maybe I've been a bit...
Take control and sell goods in order to
Exactly.
recover.
Exactly. Exactly.
Oh, sorry, where are we reading from now?
4.1.
4.1. I see.
214.
I was just querying the shorthand of recover
Yes. No, thank you.
as take control and sell because it means take control of goods in order to.
Yes. Thank you.
But we've seen at an earlier stage that a provision as to what the enforcement agent may recover, and this includes sums provided for in Schedule 12 and the regulations.
Yes. We're about to see in the table to this regulations what those figures are. I have 2 points to say just to complete the overview. The first is Regulation 16, which is the one that gave rise to this appeal. Disputes. And the issue is that there's complete silence as to who should be the respondent to such an application in paragraph 16. And lastly, before I move on to my 4 arguments,
Do we get any help from the relevant rules of court?
unfortunately not. I can show you them, but unfortunately they're equally silent. They are in the CPR, but it is rule 84.16 I started with.
Well, you don't need to take us to it if the answer is that it doesn't tell us.
Thank you. Very last point is table 1, because you're going to hear the word compliance stage argued, and so you can see what's meant by the compliance stage. Table 1 has the fees under a High Court writ and a non-High Court writ. They are higher under a High Court writ, as you can see. Both the fixed fee is higher and also the percentage fee is higher, because the sum to be recovered applies from a lower amount. But there's a compliance stage. And I mention that because I'm going to talk about the compliance stage shortly.
Forgive me.
Yes.
Is it common ground that these fees are the officer's fees?
No. So I don't think it is. That's certainly my position. That's the association's position. I don't think it is common ground.
I see. But it's only fees to which the officer is entitled, which can be recovered under the writ.
That's certainly how the writ reads, yes. The issue is that the regulations, like in the blunt, the regulations refer to an agent. That's
Well, it refers to the agent recovering them, but it doesn't say they're his. I mean, the agent recovers the principal debt, but it doesn't mean it's his.
My lord, you're making my points. I endorse that.
I mean, his role is to recover monies via seize goods to recover monies
Yes.
as agent for somebody, and what he recovers, as I understand it, are sums which will go to the principal debt, to the
Yes.
judgment creditor, and costs, and also fees.
Yes.
And there's no reason why the fees need to be his any more than the principal debt is his. That's your argument.
Yes.
And to what fees the enforcement agent is entitled is presumably regulated by the contract
Exactly. It's a private
between the officer and the agent.
Exactly.
And is there a standard form of contract, or what was the contract in this case?
There's no evidence as to the contract. I'm not sure. You say, your lordship says regulated. I'm not sure there are regulations in the sense of.
I don't mean regulated. It's governed by.
Yeah, certainly. I believe that's a private matter between each HCO and each enforcement agent.
Wasn't it rather important for us to see to know what was the contractual relationship between the officer and the agent in this case?
Well, Mr.
What is the-
Mr. Brown has, I can tell you, in this case, Mr. Brown acted as a self-employed, possibly employed by his own company, and he contracted with DBCL, Direct Collection Bailiff Limited. I don't have the terms of that contract, unfortunately. And I would say it would be unfortunate if a judgment debtor has to make an application for pre-action disclosure in advance of making an application under 80.16.
No, but all of this potentially strengthens your case.
Yes.
What you've got is a scheme under which the High Court enforcement officer has a writ which enables him to recover certain fees.
Yes.
The fees are set out in a table in the regulations,
Yes.
which relate to the enforcement, and the enforcement agent, if he chooses to get an agent to act instead of doing it himself, is tasked with the responsibility of getting in the goods, selling them, and paying that money, accounting to the creditor for the balance if it's less than what's due, or amounts to what's due, and if there's any surplus, accounting to the balance for the debtor, although that money that on any view has got to go into a bank account which is in the name of the HCEO.
Exactly. I was about to move on to my first argument, but that more or less was it, which is that because the bank account is in the name of the HCEO, they must be the legal owner, and so the dispute must involve them. They must be a respondent to the fees assessment. And sorry.
No.
Oh, apologies. Just to finish the point, then, this is exactly my first argument, the bank account argument.
But the HCEO can't be the legal owner of the money that's going to be used for satisfying the judgment debt, can he?
Yes.
Well, there's a shows in action.
It's trust.
There's shows in action.
Oh, I see what you mean. Okay, sorry, that was a
it's
stupid
in the bank.
question.
The bank says who is the shows of action given to? Well, it's the account holder.
All right.
And the account holder must be the legal owner.
Exactly.
Yeah.
Can't be
There may
anybody
be a
else.
trust. There may be a trust.
Exactly. You can have an interesting question about who's the beneficial owner. I don't need to go there, but they're the legal owner, and that's enough.
He's under a liability to account to the creditor for the amount of money due to the creditor
Yes. They made.
after deduction of the fee.
I agree.
I mean, strictly speaking, the legal owner of the money is the bank.
Yes.
But
Well, yes, but it's the shows in action.
There is a shows in action. You're
And
right.
if the HCO is not a party to the fees assessment, the outcome of the fees assessment will be that a certain amount goes to the creditor, a certain amount goes to the debtor, a certain amount goes to the enforcement authorities. The enforcement agent can't go along to the bank and say, please release the money. The bank will say, well, you're not the account holder. It doesn't work to have.
Well, what's more, if there was a determination by the court as against the enforcement agent,
Yes.
the High Court enforcement officer might say, well, so what?
Well, exactly.
They're in my bank account. Nobody joined me to those proceedings.
Yes.
I'm not bound by that.
Yes.
If you want your money back, you better claim against me.
Your Lordship has it. That is exactly my first argument. And it's supported by the text of the writ itself, but I feel the court has that, the monies to which you are entitled.
I mean, it's all very well. It's all very well to talk about who is recovering the monies, but what counts for these purposes is who would have to account to
Yes.
them, for them,
Yes.
to the judgment debtor.
Exactly. And one of the mistakes made in the courts below was to think recovery meant that. In fact, recovery has a specific meaning: take control of goods for specific purposes.
Yeah.
That was my first argument.
Well, you have a following wind from, at least certainly from
Yes.
some members of the court.
Thank you. Perhaps this will be harder. This is the Lord Legate argument, which I have been promising to talk about for quite a while. I'd like to do so now. This is the only time the Court of Appeal has considered the taking control of goods for the 2014 reforms for High Court writ. It's at tab 23. It would be helpful if I quickly summarise the facts of the case so that it won't actually affect the dicta I'm going to look at.
So this was delivered at a time when Lord Legate
It had just
had been
been
appointed,
Exactly.
but a judgment was left over.
Exactly. And it's a case about two writs. Same judge. Should I pause while the court reads the head note?
This is one about competing writs of control.
Exactly. Who gets there first? The first writ was enforced by a control of goods agreement with a promise to pay. Second enforcement agent comes along under the second writ, threatens to take away all the goods, including those covered by the agreement. It's paid off, and then Agency 1 applies for a direction that Agency 2 gives it the cash. Those are the facts. So, if I could turn to the page 401 where the judgment begins. And it's second paragraph. It's the final sentence of that paragraph. Lord Legate says, enforcement of the power under Schedule 12 may only be by an enforcement agent who is either an enforcement officer on whom the power is conferred or another enforcement agent who's been authorised by the officer to act under the power.
I'm so sorry, I'm lagging behind. Which paragraph are you reading?
Well, paragraph 2, the final
Paragraph
sentence.
2, thank you.
That supports your argument that an HCEO is exempt.
Yes, exactly.
Yeah.
So,
And it makes complete sense.
and it makes complete sense. Now, I was actually going to give what Lord Legate is saying, just to take a step back, but my Lady Justice Andrews is ahead of me. What Lord Legate is saying is that there are two types of enforcement agent. You've got the HCO, on whom the enforcement power is conferred, or you have someone else who he authorises.
Yeah.
That's what he's saying. Now, I suppose I could pause there. I have some respectful speculation as to why he said that. I don't know how much the court will be assisted by it. I mean, I'm trying to take through 3 reasons why he might have said that. But that's Lord Legate's clear opinion. The third reason is going to be the Courts Act argument, which Lady Justice Andrews is ahead of me on.
Sorry, so is this sentence necessary to the decision, or is it
No,
a passing observation?
I don't think it was. I mean, that's an interesting question, my lady. So, if you look, for example, I don't want to just throw you into the middle of the judgment, but maybe the easiest way to answer your question. Turn to page 414, for example.
Which paragraph?
61 and 62. It's quite a complicated judgment. There are lots of arguments banded around either side. One of them is the question of claiming conversion. This is what Lord Legate says about conversion. I'd only emphasise that he talked about enforcement officers serving on conversion.
Yes.
So it may be obiter. Is my answer, because the matters in discussion were not who is an enforcement agent, who is an enforcement officer.
No, exactly.
But I don't think it was a mere typo. And the reason I mentioned paragraph 6162 is just because Lord Legate talks about the rights of enforcement agent to claim conversion. But it may be obiter.
So it's a summary of paragraph 2.
Well, that's. I said there were 3 reasons why he might have said this. The first might be paragraph 2. Should we look at that right now?
Yeah.
That is back in tab 9, page 62. Now, paragraph 2 doesn't. I'll pause.
Forgive me, we're looking at section 62, are we?
We're looking at
Paragraph 2,
of
Schedule 12.
Exactly.
Oh,
page
sorry.
62. It's unfortunate when the page numbering matches the sections. Page 62 on tab 9.
Well, there's also a little bit of help, in fact, on page 55, paragraph 62, but we can come back to that.
It's quite a condensed summary because you have also to go to the definition of enforcement agent in
Yes.
I forget where that's
But
defined.
subparagraph 3 is blindingly obvious with greatest respect, an enforcement agent, if he is not the person on whom an enforcement power is conferred.
Exactly.
So that envisages that there may be one person who has an enforcement power conferred by, presumably, the writ of control, and another person whose only power derives from the authority of the person on whom the enforcement power is conferred by the writ.
Exactly. Exactly. And therefore, an HCO is an enforcement agent. Yeah. And in thinking ahead to these regulations...
Does it mean an HCO is an enforcement agent, or an HCO may be an enforcement agent? There's a difference, isn't there?
Well, I didn't read this as saying... no, I mean, there is a difference, certainly, but I read this as saying they are. As I say, if you imagine a...
It means an individual authorised by section 63(2) to act as one. Well, that's subsection 1. Enforcement action means someone authorised by section 63(2). I read section 63 2
yes, page 56.
As person acting under a certificate or someone who's exempt. And then you look at subsection C, person appointed under section 2(1), court officers and staff, and that includes an HCEO.
Yes.
So he's authorised, he's actually falls within the definition of enforcement agent.
Yes.
That is confirmed by subparagraph 3 of Schedule 12.
Yes. Because
he is a person on whom an enforcement power is conferred and therefore is an enforcement agent.
Exactly. But this is...
But also, if you look at... Go back to page 55, section 62. Schedule 12 applies where an enactment, writ or warrant confers power to use the procedure in that schedule. Right?
Yes.
That indicates that a writ may confer such power.
Yes.
An enactment might. You might have that power conferred by regulation. But also the writ may do it.
Yes.
Well, the only person on whom the power is conferred by a writ is an HCEO.
Exactly. Well, exactly. That is my second argument. I have one further point.
It's actually bizarre contention, in my view, that a High Court enforcement officer can't enforce.
Yeah.
Well,
I mean, it would be...
I agree.
The fact that in practical terms they rarely do it themselves, but farm it out to enforcement agents is probably just a matter of pragmatism, because there's too many enforcements going on.
Exactly, because there are 46 HCOs, there are 70 to 90,000 writs. Each one has approximately 2,000 a year to deal with. 10 a working day, thereabouts. Yes.
So that doesn't completely solve the problem of who you recover it from, because there is a respectable argument, and you will be obviously addressing us to the contrary, that whatever else it means, it could mean the particular enforcement agent who is tasked with the job of getting the goods from the particular judgment debtor, that is the person who is envisaged under Schedule 12 as being the respondent to any dispute about the fees. That, I think, is the main argument you're going to have to meet.
Can I address that right now? I think that's quite a difficult argument, because there could be more than one enforcement agent doing it. You could well have one turn up on day one, another turn up on day two, and the third be in charge of selling.
But the fees will be different.
The fees may be different, but there may still be an argument as to which fee was incurred at which stage. You don't need to go into the details, but in this case, we denied that the first and second stages had been met. And if they hadn't been met the first time, maybe they could be met the second time. It gets quite messy if you have to say it was this fee charged by that person, when in fact, in reality, all the fees are collected under the same writ. It makes sense that the HCO, the only single individual who must enforce the writ, is the respondent.
So, who was the agent here? Was it Mr. Brown?
Mr. Brown.
Mr. Brown?
Mr. Harry Brown. Yes.
Not the company?
No, I'm not sure the company could be an enforcement agent, because of the wording of section 63. I suppose it says an individual may act as an enforcement agent only if one of the following
Yeah, it talks
applies.
about an individual
Yeah, I
rather
think
than
it
a
would
person.
I think it would be strange for a company to be an enforcement agent.
So, yes.
How
So the
would it-
company can't be an agent.
Yes. Yeah. Can I, just returning to this Lord Legate argument, I'm calling it, perhaps it's a bad description, and I was speculating as to why Lord Legate held that. We've looked at paragraph 2, which is what's referred to in his judgment. Just a potential reason might be found in the HCO regulations. So let's turn to them. This is under tab 8. I want to look at page 50, regulation 13, fees.
Sorry, page?
Page 50 of the bundle under tab
50,
8.
thank you, sorry, I misheard you.
And this, I'm just providing another reason why an HCO could be considered an enforcement agent.
Oh, yes.
And it's, by the Justice Andrews has it, that it says an enforcement agent using the Schedule 12 procedure to enable, proceeds insufficient to enable the enforcement officer to recover the compliance fee. Compliance fee being the £75 initially due. And this adds statutory weight to Lord Legate's construction of section paragraph 2.
Well, just to be clear,
Yes.
we have the Courts Act, tab 7.
Yes.
Is it clear that an HCEO is appointed under section 2?
Yes. I mean, in my submission here is that it isn't entirely clear, no. And what I would say is that if an HCO is not appointed under Schedule 2, this is the third reason why I think that it justifies Lord Legate, which is the Courts Act reason that they're an exempt enforcement agent. The question is, who is appointed under Section 2 of the Courts Act? Now,
I'm so sorry, I'm being slow again. Where's the reference to being appointed under section 2?
maybe I'll start at the beginning and then return to my Lord Justice Phillips' question. So here's a third reason why Lord Legate might have given his judgment in those words. If you turn back, my lady, to page 56 under tab 9, and this relates to a comment made earlier by my lady Justice Andrews, which is that an individual may act as enforcement agent only if one of these applies. 2B is exempt. And exempt is either a constable, HMRC officer, Welsh Revenue officer, or a person appointed under Section 2. And my contention would be that that would encompass an HCO. And then to make that good, we need to turn to the Courts Act. I'll pause for a moment.
This is permissive. It's saying who may act as an enforcement agent.
Yes.
It's not a general definition of an enforcement agent. So it's not saying when we use the phrase enforcement agent, this is what we mean. It's saying this person may act as an enforcement agent, but it doesn't necessarily mean in a particular case that they are so active.
It does say only if one of these applies.
Yeah.
So as I read it, I mean, I suppose this observation supports my argument, but as I read this section, it was saying the following individuals are the only ones who may act as enforcement agent.
Yeah.
A, B, and C.
I think the only issue we're looking at it, as I understood it, was can an HCEO act as his own enforcement agent?
Yes.
Yes.
And the point is that the only obstacle to that would be whether he comes within section 63. And my understanding is what you're saying is he does, because he would be exempt
That's exactly
by
what I'm
virtue
saying.
of
Courts Act.
being appointed under the Courts Act.
Yes.
That's the argument we're
That's
on
the
here,
argument.
isn't it?
Exactly.
Yes.
Exactly.
Yeah, no, I understand that argument, but does it necessarily help us if what we're asking is, in a particular case, who is acting as the enforcement agent? Does your argument involve that an enforcement agent, stricto sensu, i.e. excluding an HCEO, can act as an enforcement agent and simultaneously the HCEO who instructs him is also the enforcement agent? Is that your argument?
Yes.
Right.
That's
let me
why
just
Lord
get.
Leggett's,
Sorry, can I
statement.
just get a note of that?
So can you say the proposition again?
So it's exactly as Lord Leggett said. There are two types of enforcement agents. There's a High Court enforcement officer,
Yes.
and there's enforcement agent he has authorised.
Yes.
Exactly as we saw in paragraph 2 of CES and Master.
How does one see that Mr. Brown was authorised?
That may be in the evidence, but it would just be a witness statement saying, I was authorised. I can check. There is no...
But if you're going to go to somebody's house executing his writ,
Yes.
presumably you must have some written authorisation somewhere to show.
One would hope so.
Otherwise, you're at extreme peril going to somebody's house to take their goods if you haven't got some clear evidence that you're authorised to do so.
Well, I agree, and one of the issues debtors sometimes face is that they challenge the man, provide proof, and they don't. It's a peril for the debtors too, because the debtors in a situation where
Can't interfere.
they can't interfere, it's an offence, they can't afford to get legal action, to take legal action, take legal advice. Maybe they might not know about it, the law is terribly complicated.
Well, you think the very minimum they would have would be a copy of the writ and a copy of their authorisation.
You would hope so.
If they don't have those two, it seems to me somebody would be in their rights to say, well, I don't know who you are, or what right you've got to do this.
That would be logical. I'm not aware of that being in the regulations.
But that's not an issue in this case, is it?
It's not an issue in this case. No. The issue is that Mr. Brown attended and breached an order of Master Davison.
Yes, I know that.
We'll get there.
And his companion. Don't forget there were two of them.
Indeed.
With video cameras.
Indeed. Indeed.
But the point, it seems to me, is that what surprises me is that here is somebody who has to be authorised,
Yes.
pursuant, presumably, to some form of contract,
Presumably.
of agency, but we don't have it. Well, that's a question about
I'm
the
afraid so.
respondent will
Mr.
have
Brown
to
has
deal
never
with.
seen this information. I think we were following through the reference to exempt to the Courts Act 2003. And I was arguing that that meant an HCO was exempt. It's not entirely clear that an HCO is someone appointed under Section 2. I will say that, but just make the question. All sorts of individuals are appointed under Section 2 of the Courts Act. I've done some research. I think the magistrate's clerk is an example of an officer appointed under Section 2 of the Courts Act. But surely a magistrate's clerk doesn't have the power to act as an enforcement agent executing a writ. And the only person I can think of is the HCO. My another friend has an interesting observation on this, which relates to the CPR. And he quite rightly says the CPR is inconsistent with the contention we've been discussing. And I'd like to quickly look at that. CPR is under tab 6. And it's in the practice direction 84 on page 26.
Sorry to
Please.
interrupt, Yes, I'm being annoying, I know. Just to go back to this question of
Yes.
whether or not the enforcement officer is appointed under Section 2.
Yes.
I've just been looking at Regulation 6 of the HCEO Officers Regulations,
Mm-hmm.
and that refers to authorisation by the Lord Chancellor.
Yes. So that's another
So,
point.
so is authorisation by the Lord Chancellor enough?
So that's another point made by my learned friend, which is that, and to make it even stronger, if you look at the Schedule 7, paragraph 2, on page 35, says enforcement agent is the person.
Sorry, just let me catch up.
Apologies.
No, I'm by far and away the slowest person in the room. Sorry, so Schedule 7
Of the Courts Act on page
Courts Act.
35.
page 35, right. Let's have a look at that.
There's a question my friend raises about the difference between an appointment and an authorisation.
Surely an appointment carries with it authority.
Well,
Right.
indeed, but I think that does go to my Lady Justice Lang's observation about the regulations, because it comes from the Act itself, Schedule 7.
So an enforcement officer is an individual who is authorised to act as such.
Yes. So
So it goes back to the question, is authorisation and appointment the same thing, or is it something different?
exactly. In my submission, no difference. Or perhaps there is that he's first appointed, then he's authorised, but.
Because visions of angels dancing on pinheads. Here.
Well, indeed, it does matter, because
But
otherwise,
it does matter, doesn't it?
what is this reference to an exempt enforcement agent? It can't be a court usher
No,
appointed under Section 2.
somebody's got to be appointed under that section who can enforce, and the
Yes.
only candidate is an HCEO,
For a High Court writ, yes.
QED.
For a High Court writ.
Well, that's something that the High Court Enforcement Officers Associations might have been able to help us with, how they actually appointed and authorised.
It would be very helpful. I'm grateful for the intervention of the association, but it does leave some unanswered questions. I think I'll pause for a moment. I was addressing a wrinkle in this argument. A wrinkle in this argument, which can be found in the CPR under tab 6, Practice Direction 84, which is about how do you become a certificated enforcement agent. And if you look on page 26, you can see the documents to accompany application for issue of certificate. And the problem for me arises actually over the next page. Various documents need to be provided, passport photographs and so on. But under E, there's proof that the applicant has achieved at least a qualification on taking control of goods at or above level 2 of the qualifications in credit framework or equivalent. That's the equivalent to an A to C GCSE grade, as determined by a nationally accredited awarding body. Or B, it's been authorised to act as enforcement officer in accordance with the HCO regulations 2004. Now, that's quite odd, because on the one hand you have this individual with their GCSE equivalent qualification, the other you have one of these hand-selected 46 individuals appointed by the Lord Chancellor. But it does suggest that an HCO is not an exempt enforcement agent because they still require certification. I find this quite strange. I mean, I don't know why an enforcement HCO would want to be an enforcement agent. It seems that want to be an enforcement agent properly so called would want a certificate. All I can say is that this is in the practice direction. I didn't see it in the certification regulations. And it may be a mistake, or it may just permit an HCO, should they so choose,
To get a certificate.
get a certificate. And they have a bit of a shortcut, so they didn't need to take the qualifications. They've actually got much higher qualifications. My Lord, it looks as if you want to say something.
No, I'm just thinking about it.
I'd like to move on to my third argument. I'm conscious of the time. The first two have been about the legal ownership, and the second has been what I call the Lord Legate argument. There is no distinction. There is only sometimes a distinction between an HCO and an enforcement agent. My third argument is about paragraph 66. And in light of the time, I have to take this quite quickly. We're on tab 9, page 74. It's the related party argument. So, in order to show, in order to bring a claim onto paragraph 66, there has to be a breach of the schedule, and that claim can be brought against a related party. In respect of damages. And we've discussed the related party question, I think, sufficiently. My position is that the related party encompasses an HCO. They are the person on whom enforcement power is conferred. That's the clear wording of the writ. What would paragraph 6A ever refer to if it wasn't the HCO? It would be an empty reference if it was the enforcement agent themselves. And I have, obviously I rely on the reasoning of Mr. Justice Lambert as well. If the court is content with the first part of the argument, i.e. there is jurisdiction to bring a claim for a breach of Schedule 12, then I would move on to my second limb, which Mr. Justice Lambert is against me. Has there been a breach of Schedule 12? I would like to look at the language of Mr. Justice Lambert's judgment, if I may. In my submission, it betrays respectful submission. It betrays a slight mistake as to what's happening. If you look at tab 4 of the full bundle, I apologise. Take up the full bundle. And paragraph 28 is where Mr. Justice Lambert addresses my argument about paragraph 66. And I'll pause.
So the question is submitting incorrect fees a breach of?
Schedule 12, yes. Though I do take issue with the premise, because there is no submission of a bill of fees. It's not like an accountant at the end of the day delivers up an invoice. What there is recovery of goods. The enforcement agent goes in, takes control, sells them. Submitting a bill of fees somewhat betrays a misunderstanding of what's happening in my respectful submission. And of course, that's what happened on the facts here. Mr. Brown demanded the full amount, took steps to enforce the judgment writ, via the writ, and then was paid in cash via a payment agreement.
Takes too much money for what he is. He takes more money than he's entitled to for the service he's rendered.
Exactly.
And he is under an obligation, in fact, to account to the debtor for the surplus.
Yes, under paragraph 50.
Under paragraph 50, yeah.
And there's also, so I simply say there's a breach of 2 paragraphs. The first is paragraph 12, excessive enforcement. That's the paragraph that says you can only take control of goods to the value of the amount recoverable and the fees likely to be incurred. I apologise for being quick, but this is only my third argument. And we have looked at paragraph 12. The second paragraph is paragraph 50, as my Lady Justice Andrews alludes to. There is an immediate requirement to return the surplus to the judgment debtor, and there would be a surplus if the wrong fees are levied. And because there can be a claim brought under paragraph 66 against the HCO, there must be a party to the fees assessment, because it's the other side of the same coin. It really is a process of determining, has there been a breach, paragraph 12? Has there been a breach, paragraph 50? Because the question is, what are the right fees? And there's a dispute as to that.
You could actually have a situation where there's no breach as yet.
Yes.
Where the money's just sitting in the account and it can't be dispersed until the court's resolved how much is due.
I'm not sure. If by the money sitting in the account you mean money in the HCO account, then I would submit there would have been a breach. The breach would have been committed at the time of taking it from the debtor. That's the date of breach. And if you're thinking about damages for such a breach, you would time those damages from the date of
But it's
taking
got
the
to
money.
go through the bank account in order to be paid back to the debtor, so I don't think that can possibly be right. The regulations envisage that any surplus that's paid to the debtor be paid out of that account.
Yes,
Specifically.
but
So putting it into the account in the first place can't be a breach of anything.
I'm not sure if I agree. Maybe we are looking at paragraph 12.
Depends what you put into the account in the first place.
If you
Proceeds of sale.
If you take, that's the proceeds of sale, but the same account will be used for simply demanding cash. It would also be money is recovered.
Well, let's keep it simple. Let's assume that they sell the main vase and they put the proceeds into the HCEO account.
Yes, and if
Is that a breach?
if they've sold too much, if he's taken control of goods whose aggregate value is more than the amount outstanding and the amount of future costs, that is a breach. Paragraph 12.
Well,
It's actually a breach.
only if they.
Let's just get to
Sorry, I apologise.
12 in
We're
front of us.
we're on tab 9, page 66.
Right, so paragraph 12.
And this is this is the modern instantiation of some very old law about excessive enforcement, medieval law. And my submission is, in answer to Lady Justice Andrews' question, if an enforcement agent takes control too much, whatever his incentives are, whether he's minded because he thinks the fees will be greater than they are, whether he's just malicious or whatever, makes a mistake, that is a breach of paragraph 12. It's a breach subject to a defence.
Subject to subsection 3.
Well, 3 only helps for
It's the
the valuation
value
of
of
the
the
goods. Exactly. Exactly as my Lady Justice Laing says, right? Valuation of the goods, but not if he knows what the goods cost and then takes too much of them. If it comes the price tag saying just bought from a shop, brand new, resale value £100, and he takes too many, then subparagraph 3 won't help him. He could be assisted by the defence in para 66 about acting under the reasonable belief that he was not reaching a provision of the schedule. Because he might say, well, I genuinely thought the disbursements would be this. I thought we were going to use this auctioneer, and we're actually using that auctioneer. He has a defence if he was acting reasonably. And I would submit that if it's something like VAT, which is what the underlying dispute was, that it wouldn't be acting reasonably. That's either here or there because the point has been conceded. So there is a claim for damages under paragraph 66. That claim is based on breach of paragraphs 12 or paragraph 50, and that claim is brought against the HCO. Therefore, the HCO must be the respondent to the fees assessment. That is my third argument.
Right, so the HCEO can undoubtedly be a respondent to a claim for a breach of Schedule 12. That's
Yes.
the first step.
Yes. The second step is there is a breach of Schedule 12 if the wrong fees are levied. And also Schedule 12, paragraphs 12 and 50 specifically. That's the second step.
So the second step,
Is that there is a breach of Schedule 12
the wrong fees are levied.
if the wrong fees are levied.
Yeah,
Specifically, paragraphs 12 and paragraphs 50.
yeah.
And the fee assessment determines whether there has been a breach. And there are other defences that may be brought in, but that's the fundamental question, whether the right fee is charged.
But is that putting the cart before the horse? Because isn't the first question what fees were due, and that's resolved by a dispute under Regulation 16?
Yes, but what fees are due is not necessarily a question you'd know in advance. In the typical cases...
Well, no, quite. That's why Regulation 16 exists, presumably.
Yes, but I think I've lost my lady's point. Sorry.
Well, no. All I was suggesting was that the primary way of finding out what fees are due is a dispute under Regulation 16, and it
Yes.
might not be until you've ventilated the dispute under Regulation 16 that you'd know whether or not there'd been a breach of Schedule 12.
Well, absolutely. That's the whole point. The assessment will determine has there been a breach, and then
Right.
the proceedings brought under paragraph 66 would seek damages for that breach. For example, interest from the date in which too much was taken.
You're saying it's all bound up together, and it would make no
Yes.
sense for one part of the inquiry to be levied against person A and the other part of the inquiry to be levied against person B.
Exactly.
That's the point.
That's the point.
I see the argument. It seems to me it's quite a convoluted argument for saying why the enforcement officer needs to be parties to a fee dispute, when there is a much simpler answer, which is they need to be parties to a fee dispute because they have the fees.
Well,
So I'm not sure.
That was my first argument.
I'm not sure that this really adds an awful lot to the point that if the money's in the enforcement officer's bank account and they're his fees, he needs to be party to that dispute.
Yes, and
Justice Lambert, of course, took the view that they weren't his fees because Mr. Brown earned the money for the services rendered by Mr. Brown, and no part of that belonged at any stage to Mr. Williamson.
That's quite right. And I think that was based on an error of misunderstanding the different roles.
Yeah.
One of the importance of paragraph 66, and its fundamental importance, that's why I mentioned it in my opening, is the question of is the HCO there to be responsible for, to give oversight to the enforcement agent. I say you can see that from their liability, because this paragraph 66 presumes some sort of vicarious liability,
Yes.
because you can sue them for the acts done by the enforcement agent. You can sue the principal of the act done by
Which
the
was always the position at common law, and you say hasn't changed.
Well, that's my fourth argument, which I'd like to get to if there's time before lunch. But yes,
What basis is there for, what argument is there that the fees set out in the schedule are those of the enforcement agent?
well, you're asking me to argue against my own client. I mean,
No, I'm asking you what
Reasoning so far.
I'm asking you what the argument is.
the reasoning of Master Sullivan and Mr. Justice Lambert was simply the regulation throughout refers to fees, therefore the fee assessment, refers to enforcement agents. Therefore, the assessment must be against enforcement agents. That's
Yeah, but what? But the
Well, I
only,
think
the
it's a
only,
good argument,
the only
but that
sense
is-
in which it would make sense for an enforcement agent
yes.
to be the respondent would be if they were the enforcement agent's fees. But I see nothing at the moment in the regulations to say that they are the enforcement agent's fees. The enforcement
Well-
agent is presumably paid pursuant to his engagement,
Yes.
whatever has been agreed with him.
That's
And we know some of those fees can't be the enforcement agent's fees. The compliance fee isn't the enforcement agent's fee
yes,
because the enforcement agent hasn't been appointed at that point.
indeed.
So there's no doubt the enforcement agent is recovering what are at least in part the officer's fees.
Yes.
And it seems to me there's nothing in any of the regulations I've seen to say these are the enforcement agent's fees. What we do know from the writ and from the structure is that the fees are those of the officer.
Yes. Absolutely.
So at the moment, I'm struggling with the very basic question of why would an enforcement agent be the proper respondent to dispute about the officer's fees?
Well,
And that seems to me the be
Yes.
all and end all of
Yeah.
it.
yes. I agree with that. I mean, there's actually something that's quite concerning about the facts of this case, which is that the evidence before the court was that Mr. Williamson had no entitlement to the fees. He gave a sworn witness statement to that effect. I don't doubt the veracity of that evidence, but it just means that he's in breach of the various regulations we've been discussing.
He may have a genuine belief that he's got no entitlement to them. It doesn't mean to say that's the actual
How does he get
situation.
paid? How does he get paid then?
Well, indeed. I agree that Mr. Justice Lambert says there's no evidence, this is paragraph 27 of page 50, that there was no evidence that Mr. Williamson was entitled to recover a share of those fees. She sees it as a matter of evidence.
Well, is it because he was the director of the company that he appointed? He gets paid that way.
Presumably, he gets dividends, he gets debt remuneration. A clever accountant can think of a number of ways.
But that seems to me isn't the way it should be done.
Well, again, it's. I see this as a. I think the association would agree with you. I see it as a private matter between the HCO and construct their business as they choose. And if they form a contract with the enforcement agent that says, "I'll immediately pay you 50%," then
Well, if they agree, if the officer agrees that the agent should have all the fees,
yes,
then so be it.
yes,
But that doesn't mean the fees are the agents. That means the fees are the officers, which the officer is agreeing should be paid to the agent.
yes.
Yeah. But you're agreeing with all this. It may be a pointless exercise. We need to hear from the respondent
Thank you.
on it. But just want to be clear what that is your case.
Yes, that is exactly my case.
Yes.
That's my case on my first argument. I mean, I do place weight on this paragraph 66 point because it presumes this underlying liability, which I think is terribly important because it's the point I'm going to touch on. What happens if there is no supervision? What happens if you have this tremendous power from an enforcement agent without the supervision of an enforcement officer?
Well, I think we have the point.
Yes, I'm going to
Do
move
you want
on
to move on to your
final point,
final point? Yeah.
which is the my lady and Justice Andrews alluded to it. It's the historical argument. It's that this was the law before 2014 and it remains the law afterwards. Just start with the Courts Act, Schedule 7. We've seen it several times. It is the starting point. If the court turns to paragraph 4 of Schedule 7, and behind tab 7, page 36. Four subparagraph 2. As the relevant officer, the HCO, as in relation to the duties, powers, rights, and privileges and liabilities of the Sheriff of the County. That's what's importing.
Would have had.
Would have had from the law.
So liabilities.
Exactly. Liabilities is the word. And I believe it's common ground between me and my learned friend that historic position was a liability for all the tortious acts of bailiff. In light of the time, I won't take you to Roaring Cutton in 1832. It's undoubtedly a very old rule for the protection of debtors. security of the king's subjects. Perhaps
Sorry, what was the name of the case again?
Raw and Cutton.
That.
I can, if the court is interested in the position.
Well, just maybe just give us the tab number.
Tab 15, page 221.
Thank you.
It's actually it's a proto-bankruptcy case. It's quite interesting. But let's move ahead.
I'll take your word for it.
Interesting for insolvency lawyers. My learned friend actually accepts.
Chief Justice Tyndall, isn't it?
Yep, exactly.
Yeah.
And the relevant part is marked on the right.
Yes.
My learned friend accepts in his skeleton argument that the sheriff was liable for the tortious acts of the bailiff. There's actually some disagreement between us as to whether or not a tort is being committed when the wrong fees are charged. And this is going to relate, I'll take it quite quickly, because it's the same argument as paragraph 12 that we've been having, but without the structure of paragraph 12. I won't take you to the statute of Marlborough. I will mention the decision of Mr. Justice Hilbery in Watson and Murray from the 50s. And the passage I'm going to mention is the paragraph.
So that's the next tab.
Were you on tab 8 tabs? Yes.
Yeah, I was on
Yeah, so
15.
if you're there, my lady,
Yes.
then maybe this is a case about a women's clothing shop that wasn't doing terribly well, had lots of judgment creditors. And on one writ, bailiffs were instructed and they removed 120 women's garments. And if you turn to, and that was said to be too many, they weren't entitled to take that many garments, 120 is too many for the judgment debt. You turn to page 233. It's the last paragraph of 233 that concludes at the top of 234. Mr. Justice Hilbery says that I apologise, I've been checking the wrong reference. It's 235.
Yeah, I was going to say.
235 to 236. Apologise. I highlighted both, but it's the
First
second.
alleged breach of duty was that they wrongfully seized goods of greater value than sufficient.
Exactly. Sufficient to pay the debt's interest, and this is the key word, poundage and expenses. Poundage being the historic word used for sheriffs. So,
He doesn't say so expressly, but that's a tortious breach.
Yeah.
well, he says expressly that taking too much is a tort.
What is it? Sorry, I've missed that. I read it too
Just a
quickly.
breach of duty.
Oh, sorry,
He said he doesn't. I don't think he uses the word tort.
he doesn't
He
use
says
the word
breach of
tort. I
duty.
apologise. He uses the word wrongdoer
Yeah,
And breach of duty.
and breach
yeah.
of duty.
So your submission is what he's saying is that that's tortious behaviour.
Yeah, so it's illegal wrong.
Yeah.
I don't see what else it could be other than a
No,
tort.
exactly. Okay.
And it's
Well, now it probably breaches statutory duty.
now it would be breach of statutory duty. Yes, under paragraph 12,
Which is a tort.
which would be a tort as well.
Yeah.
So that's the law pre 2000, the 2007 Act. That there was a tort for which the sheriff and then HCO was vicariously liable. Question is, what has changed now by the 2007 Act? There's a lot to say about the vicarious liability of an HCO for acts of the agent. And I referred in my skeleton argument to a passage from Professor Attia's textbook, predating 2007. And in it he gives two justifications for this historic vicarious liability. The first is as a matter of public policy.
So sorry, can you just remind us which paragraph of your skeleton?
Yes, certainly. I mean, it may be simpler to tell you if you have the respondent open.
Right.
that the passage is short. And it is behind tab 29. Is Professor Attia's discussion is the historic liability of sheriffs and officers. And the reason I say this is because in the argument before this court is that the 2007 Act changed this historic protection that debtors had. But the
Right, so the sheriff's only liable for acts of his officer which are committed by him in the scope of his authority or the course of his employment.
yeah, this is also,
Yeah.
to use the word proto, the law of vicarious liability has matured since then. We're going to look at some of those cases. But the key point is the relationship between sheriff and bailiff, and after 2004, HCO and bailiff, was one to which vicarious liability would be attached. And the question is, what's changed?
You see nothing because section 4.2 says that the liability is retained.
Exactly. I say nothing because the public policy argument is the same. You still have the vulnerable position that debtors are in, the limited access to justice, the need for enforcement to be right the first time. That public policy hasn't changed. I also say the non-delegable duty argument that the professor refers to hasn't changed. There's a writ commanding Mr. Williamson to enforce the judgment debt. Now, if he chooses to appoint enforcement agents to do so, and that is enough to impose vicarious liability. I think it's worth looking at some authorities for that claim, because it is disputed. And that's the decision in Woodland and Swimming Teachers Association behind tab 18, the judgment of Lord Sumption. This is a personal injury case, a tragic swimming accident. The argument was that the local authority had a non-delegable duty of care. And I agree with my learned friend that the key passage is the one he has highlighted. At page 336. I'll pause, but in this paragraph, Lord Sumption explains what he thinks are the factors that give rise to a non-delegable duty of care.
Forgive me, I'm not quite. If someone is acting as an agent,
Yes.
why do we need to talk about non-delegable duties of care?
Well, I think it's not the case that every agent. The principle assumes, it's not my understanding, that the law is that every time someone instructs an agent, they're vicariously liable for any act that agent carries out. That's not my understanding. My understanding is there needs to be an assumption of responsibility in addition to that. So if...
Depends on the scope of their authority.
And it depends on the scope of their authority. I mean, my lord, you may well have the point. I mean, Professor Attia has some difficulty analysing the vicarious liability relationship between sheriff and bailiff. I confess I also have some difficulty for HCO and enforcement agent. In some respects, it's sui generis. This relationship where one man is commanded to do something and then pass on that command, not commanded by statute to a public authority, but commanded to a private individual. It's a pretty unusual situation. What I propose doing is quickly running the gauntlet and looking at these factors highlighted by Lord Sumption. And my submission will be that they will apply. The first factor is the vulnerability of the claimant. I say that applies primarily due to the powers of the enforcement authorities, but also, as a matter of fact, the pecuniosity of the claimant. The antecedent relationship, I'm running through the numbers here, the antecedent relationship between the claimant and defendant, I say is satisfied through the writ, which is a command that connects the HCO with the judgment debtor. All the court would have seen that the writ specifies you, Simon John Williamson, must enforce this writ, this judgment debt against these individuals.
I mean, the problem with all of this is it's not the claimant, in this case the judgment debtor, who's being put in custody, charge or care of anybody. It's his goods.
Well, I suppose so. I mean, one could well imagine a personal injury case where there's a scuffle and the agent is in the wrong. They might still want to sue the HCO, and I say they could do. And I agree in the case of fees, which is how this arises, though I say it arises for every tort. It is the goods.
It's a lot simpler, I think, to just look at it as an instance of standard vicarious liability where the agent is acting within the scope of his authority. If he does something which he's not authorised to do, like give the debtor a black eye, may well be that the HCEO isn't liable.
Yes, I'm conscious.
You don't really need to go that far.
In which case I shan't, my lady. I would like to touch on this question, which is whether anything in the 2007 Act removes this pre-existing vicarious liability. I'll touch on it briefly because my submission is it doesn't. Firstly, there's the paragraph 66 point, which presumes a vicarious liability. Secondly, is the point that there's no express limitation as to who should be the respondent to a fees application. We've touched on that. But I'd also like to draw, of course, attention to the explanatory memorandum that's behind tab 36. Explanatory memorandum to the fees regulations. And at page 642, it's the paragraph that explains why are there higher fees for High Court enforcement. And it's the sentence, personal liability of the High Court enforcement has also necessitated the need for High Court enforcement to have first and second enforcement stages with associated fees. It's obviously not determinative, but it supports my argument that nothing in the 2007 Act meant to change this, I say, fundamental and historic protection. And I'll go further and say Mr. Williamson's approach, which is deny it, is a dangerous one and an improper one for an officer of the court. And I'm going to move on to that in just a moment.
I've got a feeling there's a bit of law about the extent to which explanatory memoranda are admissible. I'm not asking you to make submissions about it now, but I think it might help us to have a little, possibly, if possible, an agreed note on that, just so that we don't take into account something we're not allowed to take into account, or take it into account in the wrong way.
I can do, and I don't know if this reliance is terribly controversial.
No,
I don't think it's
may not be, but
enormous weight, frankly. It adds in the right direction, but I'd be surprised if the court...
All right, so you're not inviting us to put enormous weight on this?
No.
No.
Although
Okay.
it helps, and it helps the policy argument.
Right, okay.
I've alluded to.
Well, you can certainly look at explanatory notes if there's doubt as to what a provision does, either as to the scope of the provision or its meaning.
can we?
Maybe my Lady Justice Andrews could answer the question better than I can.
All right.
I'd like to say something about the intervention of the association, and that will conclude my submissions on ground one. And then I'd like to talk about the application to this case. I'm very conscious of the time. I promised my learned friend I would finish before lunch. So that concludes my four arguments. The legal owner argument, the Lord Legate HCO is an enforcement agent argument, paragraph 66 argument, and the pre-existing law unchanged argument. Has the court seen the intervention of the association? Thank
Yes,
you.
we have.
In which case, I'll say that the association gives two reasons I say in support of my appeal. The first is that an HCO is personally responsible and personally liable for any action taken by an enforcement agent under his authority. The first argument, which is my paragraph 66 / historic law argument. And the second is that any fees recovered in entitlement of the HCO, and that's my first argument, legal ownership. I do want to emphasise it's not just in this witness statement submitted in intervention, it's also in the professional conduct rules, code of best practice. It has always been the HCO's position, the association's position, that HCOs charged with enforcement of the writ are responsible for the actions of their staff. And the association might be wrong, but I do want to emphasise how radical it would be if this court dismissed the appeal. Every HCO who considered themselves responsible for the actions of their certificated agents would no longer do so, at least with respect to charging of fees, which is, of course, a significant part of the imposition of a writ. And so, I'd like to talk about the application of the law to this case. What happens if the court agrees with me on ground one? If the court dismisses the appeal, nothing happens. But if the court agrees, then the decision of Master Sullivan, when it came to the costs of the first instance, would have been based on an error of law, because Master Sullivan found that Mr. Williamson should never have been a party to litigation. And the application should always have been made against Mr. Brown, the enforcement agent. And if I may, I will summarise the facts of first instance. I'll give references to the supplemental bundle where appropriate. And then I'll make some submissions. The writ was issued on the 17th of September 2019. You can see that from second tab, page 9, the supplemental bundle. Mr. Brown visited Mr. Bowen on the 3rd of October 2019. They entered into a payment agreement. Pursuant to the payment agreement, there was the payment of £7,500 in Mr. Brown's presence, £4,500 the next day, £2,000 on the 5th of November. Mr. Bowen's evidence is that this visit from Mr. Brown led to serious problems in his marriage. You can see that from his witness statement at tab 1, the supplemental bundle. He testified that the only goods seized were either exempt or those of his mother-in-law, and he did not receive a notice of enforcement prior to the visit. The next thing that happened was that Mr. Bowen ran out of credit and could not pay more towards the payment plan, and so he applied to Master Davidson for a stay of the order. He obtained the stay of the writ on the 19th of December 2019. That's at tab 2, page 34. It's the order of Master Davidson. And Mr. Brown knew about this stay, and he visited again on the 10th of January to demand payment. Mr. Bowen's evidence was that Mr. Brown threatened to take away more goods. And you can see that again at tab 1, Mr. Bowen's statement. On the 18th of September, Mr. Bowen made the application against Mr. Williamson. That's the originating process that started this off. And there are two components to it. Firstly, it was said that Mr. Brown breached the stay ordered by Master Davidson, and secondly, that he levied the wrong fees. The details are no longer important. On the 4th of November 2020, there was a hearing before Master Sullivan. Mr. Bone was ready with his skeleton argument for the hearing of the application. Mr. Williamson denied being the right respondent, and the outcome was that Mr. Brown was added as a party. You can see that the order, I think, is at tab 9, page 94, the supplemental bundle. Yes. On the 6th of January 21, the fees element was compromised, all the fees were waived. That was communicated on the 8th of January by way of Mr. Williamson's witness statement. And then a month later, there was a second hearing for Master Sullivan. I'm going to look at this judgment quite shortly, but the Master found on the balance of probabilities that notice of enforcement was sent. But this is where it gets important, and I'd like to turn to that judgment, which is at the core bundle, tab 8. And paragraphs 8 and 9, the ones I should refer to. So there's fees question is stayed for a moment. It's only a question of cost. Fees have been waived. There's still a live question about damages, breach of the order, which requires showing a breach and then showing damages. And the learned master rejected the argument that there was no breach because there was no enforcement, despite the attendance of Mr. Brown and his colleague. And the master then found that there were no damages in respect of this breach.
Sorry, I think I'm looking at the wrong
I
judgment,
apologise.
because there are two judgments.
There are, I'm looking at tab 8 of the core bundle, the Master Sullivan judgment.
Yep, there are two.
There are several.
There are two.
I'm on page 84.
Page 84. Right, I'm so sorry, it's my fault. Yep. Which paragraph?
8 and 9 are
8
where
and 9.
the learned master rejects the argument there hadn't been a breach of the stay. And the master found that although there was a breach of the order, there were no damages due. That decision that there are no damages due is not being appealed. Obviously something I have to take as the right decision. I mean, I would say when the court writes its judgment, it doesn't necessarily approve of this decision, because there's certainly an argument that paragraph 66 is actionable per se. I'm not going to argue it here. But it would be per se. There is historic case law to say a breach of a writ is actionable per se, and it's quite dangerous to hold that it's not, because then an enforcement agent could enter into the same house day after day after day, and provided they cause no financial loss, then there's no action against them. So I invite the court not to, obviously can't dispute it, but I do ask the court doesn't necessarily endorse that element, which is not before the court anyways. Turning to costs.
There's no. The finding wasn't that there wasn't a breach. The finding was that there was no loss.
Exactly.
Yeah, so there is a finding of breach. Yep.
There's a finding of breach. That's quite significant, actually, because Mr. Brown and Mr. Williamson didn't come to court and apologise for a breach of the master's order, even though they're officers of the court. They came to court to say, nothing to see here, there was no breach of an order. And that's something I place weight on in the context of costs. Turning to the costs decisions, I think I can summarise them. Master Sullivan awarded Mr. Brown his costs in full because he only sought his costs at the hearing, and the Master thought that was the right order. That's not under appeal, I can't challenge that. But she also held that an HCO was not a correct party to the fees application, and so Mr. Williamson was entitled to his costs, both elements, both the fees element and the damages element. And she awarded costs on the indemnity basis, on the basis of drop hands offer of 25th of November.
Did Mr. Williamson waive the fees?
Well, there's an email from Mr. Brown which appears a little artificial, saying, I agree to waive the fees. I can show the court that email.
That's not what I asked, though. Did Mr. Williamson waive it?
Well, I suppose by law he must have done, but he didn't consciously. He denied being entitled to waive them.
He said they weren't his fees, and therefore he wasn't in a position to waive them.
Exactly. But as a matter of law, I think that is the right analysis, though he didn't appreciate it at the time. So
because his agent waived it.
Exactly.
Yeah.
That was his testimony. So there are these. Sorry. There are these two sets of costs. There's the Williamson costs and there's the Brown costs. I'll deal with them in turn. Williamson costs. Mr. Bone obviously the successful party for fees because they were waived. It's important to note the fees claim was larger than the damages claim. The fees claim was for £5,133.60, and the majority of the skeleton arguments concerned arguments about fees that are no longer relevant.
So sorry, what were damages were claimed?
Damages claims were for £1,000 nominal damages.
Right, for breach of duty.
For breach of duty.
Yep.
And you can see that from paragraph 5 of Master's judgment. On page 84 of the bundle.
Yeah.
So, Mr. Bone is successful in the fees claim, which is larger and I'd submit more important than the damages claim. Now, I accept that he wasn't successful in the damages claim because no cheque was written in his favour, which he sought. Or I don't accept that renders Mr. Williamson the successful party. And that's because Mr. Brown was in breach of an order of Master Davidson, attended Mr. Bone's house with an associate in full knowledge of that order, which falls in my submission far below the standards that this court should expect of its officers. Neither Mr. Williamson nor Mr. Brown came to court to apologise, as officers of the court should do, to say, I was in breach of the order, you're right, but it didn't cause any loss. They came to contest being in breach, and they were found to be in breach. So while the usual rule is that he who writes the cheque is the unsuccessful party, and he that receives it is, if defendant doesn't have no order made against them, they are successful. I don't accept that's true here.
Yes, but even where liability is established, if damages awarded are only nominal, it will often be the case that the quote successful party will have to pay the costs if all they have recovered is nominal damages.
Yes, well, I agree with that, and the costs are obviously extremely fact sensitive. The fact I'd emphasise is that this is an officer of the court found to be in breach of the court's own order, not a position any officer of the court should ever be in.
Well, of course, that goes without saying, but nevertheless, in litigation where it's all at the end of the day about the outcome in financial terms, your client didn't recover any damages.
Well,
as a result of as I understand it, from the 1st of January when the fees were waived.
Yes. Yes, in January.
January, I think you said 6th of January.
6th of January, yes.
When the fees were waived, thereafter, your client recovered nothing.
That's right.
Against either.
Yes. So at that point, I think the analysis he was entitled to his costs of the fees application. He stopped there and gone to court, not pursued his claim for damages. He would get his costs of the fees application, probably the application as a whole, because viewed in the round he was successful. But he did proceed to a hearing at which he was not successful, although I would argue that neither was Mr. Brown and Mr. Williamson. They weren't successful because officers of the court, as I've said, you should come to court and apologise when they're in breach of the order, not to contest it.
Well, we don't normally, I mean, it might be slightly different in defamation cases, but generally the judgment of the court isn't that the party apologises, it's that they pay money.
Yes.
I don't think parties generally can be expected to come to court for the purposes of apologising if they don't owe anything.
No, I'm not saying they ought to come to court. I'm saying that they should not have contested and then lost on the issue of being in breach. That's quite a significant loss.
But if they say they had made an offer saying we will accept liability accept a breach, but there's no damage, your client would have had no leg to stand on. But if there's a breach but no damage, then your client still hasn't got a leg to stand on. So, I'm not really sure where any of this gets you.
Well, he was seeking nominal damages. I don't accept that this is a...
Well, £1,000 isn't, in this context, I'm not sure £1,000 was nominal damages in the sort of sums that we're talking about here.
Well...
And he didn't get the nominal damages.
He didn't get his nominal damages, no.
Against which you're not appealing.
Correct. There's a range of possible cost orders which could be made within the court's discretion. I say that range would begin perhaps with no order as to cost, but properly should be given the more importance of the fee assessment, some sort of reduction to the Mr. Brown's costs on account of the unsuccessful issue.
But the question for us, isn't it, was whether Master Sullivan acted outside the broad scope of discretion as to costs in saying that your client should pay the costs of that part of the claim.
Well, I'm not sure if that's right. It's not about discretion because she based her judgment on an error of law, which is the incorrect joinder, the allegedly incorrect joinder of Mr. Williamson. And you can see that in the judgment. If I take you to paragraph...
Yes, so her position was that the proceedings against Mr. William were not only unnecessary, but not authorised by the statutory scheme.
Exactly.
Yeah.
I understand that, but the position that would then have to be considered would have been if Mr. Williamson was in the position of Mr. Brown, that he was a properly joined party.
I'm sorry, Mel, can you repeat that?
Well, I don't. Yes, that on your case, that error was made in relation to Mr. Williamson, but
yes.
But the effect of that error being reversed would be to put him in the same position as Mr. Brown.
Yes, and Mr. Brown only claimed his fees of today, and the Master considered that to be correct because the fees had been incurred in litigation that she thought was frivolous as against Mr. Williams. And she says as soon as Mr. Brown was added as a party, it sorted itself out in the decision of Master Sullivan. But actually that was the wrong analysis in law.
I think the point my Lord is making is, let's suppose that we cast aside Master Sullivan's approach and we were with you on the question of whether Mr. Williamson was properly joined. What then?
Yes.
You put him in the position as if he's vicariously liable for what Mr. Brown has done. There's no responsibility for any loss because there is no loss in terms of any tortious behaviour. And in terms of the levying of the fees, you've got your money back.
Because of a successful application. Because of a successful application, we got our money back. I'm not sure it would be proper to give any order less generous to Mr. Bone than no order as to costs. I'd submit the proper order would be toward his cost in full. And that is because the second fundamental question I started with, and my Lord, we discussed a few hours ago, which is how should an enforcement officer act if they disagree with their professional guidance. Now, the HCOA's intervention just repeats what was already in its guidance, which is that Mr. Williamson's position was wrong in law. And what Mr. Williamson should have done, I say, in the event of any uncertainty, is make an application to the court, add the HCOA, the association, as a respondent, maybe invite the Ministry of Justice as well, or and receive directions. The wrong approach for an officer of the court is to take a potentially contentious position on the law and then wait to be challenged. And it's particularly egregious when that officer of the court is dealing with vulnerable members of our society with limited ability to take proceedings or seek redress, like judgment debtors. And there is a bigger picture here. I want to emphasise that there are just 46 HCEOs. 1 in 46 writs were addressed to Mr. Williamson, and that's 1,000 or 2,000 a year, depending on when Mr. Williamson was first appointed. We're talking about maybe 10 to 20,000 writs of control since 2007. And I would submit that the refusal to follow the guidance of the association has potentially disastrous consequences the vulnerable debtors, who we have seen are the ones paying Mr. Williamson to do this. And we can see the consequences in this specific case. And firstly, there was the wrongful attendance on the 10th of January, and it makes no difference if there was no harm caused, it was still a culpable breach of an order of the court. The wrong fees were charged. For a man in Mr. Bone's position, paying £5,000 too much is a serious burden. And if you look at the details of the dispute, I'm not going to ask the court to tell me what was right or wrong, but the disputes are often sums of principle. One of them was a question about VAT, what's the correct VAT due? And that isn't something an officer of the court should unilaterally decide whether VAT is due, and then, when challenged, waive the fees. Not when the person challenging is a judgment debtor. So I say, in the context of the multiple failings of Mr. Williamson, the proper order would have been to award all of Mr. Bone's costs. And that isn't quite the end of the story. There's also the question of Mr. Brown's costs. There was an order of £3,000 against, in favour of Mr. Brown from Mr. Bone. Mr. Brown is not here. He's not a party. That order can't be challenged. And I accept that Mr. Brown incurred costs and that he should be entitled to recover them. The question is, who should he recover them from? Now, he was joined as a result of Mr. Williamson's intervention. And if Mr. Bone is correct on ground one, then Mr. Brown should never have been a party. And the appropriate order, I say, in this multi-party litigation is either that Mr. Williamson pays Mr. Bone these £3,120, akin to a Sanderson/Bullock order in multi-party litigation, or the cost order makes Mr. Williamson and Mr. Bone jointly and severably liable for the costs. And that's just a fallback position because I know I can't challenge that part of the order of Master Sullivan, because that part of the order was not appealed, only the Williamson part.
How would making you jointly and severally liable help?
Well, Mr. Bone has no money, if I can be blunt, and Mr. Williamson does. So one's hope would be that Mr. Williamson satisfies the order of the court.
Oh, I see, the order's not been enforced.
As far as I'm aware, it has not been enforced.
Right.
I think there have been applications for a stay, and some of them have been successful, but presently it is an unstayed cost order.
But the difficulty one comes back to with all these arguments is at the end of the day, the costs, Mr. Brown, 3,120, were incurred in relation to a hearing where your client was claiming damages which he failed to establish. And the hearing of the 20th of February 21 was entirely determined against him.
It was, but it shouldn't have been. The fees element, I say, shouldn't have, the costs of the fees element shouldn't have been determined against him. He was obviously successful for fees. I say that although he was unsuccessful for damages, I don't accept that makes Mr. Williamson or Mr. Brown the successful party. We've discussed that. And there is this bigger issue, which is what happens when an officer of the court comes to the court on application in circumstances where he's in breach of his own association's guidelines. That's not how an officer of the court should behave. He shouldn't be taking that stance against...
Well, costs are not usually awarded as a rap on the knuckles.
Well, they can be, my lady. They're not usually, but they can be. It rather depends on the conduct concerned.
Was this argument about the breach of the guidelines run in front of Master Sullivan?
Let me check the skeleton arguments for that, because we do have them, and they may have referred to the guidelines. It wasn't mentioned, I think, in the context of costs. I'll accept that. But I think it was relied on for the purposes of making Mr. Williamson a proper respondent.
Right.
I think. I would like to...
Well, we can check that over.
Yes, over lunch. I may.
Yes, of course.
Are you saying that you had to go before the master in February to establish that you were entitled to your costs against Mr. Williamson?
Yes.
Fees claim.
There's going to be
so the hearing. You had to have that hearing for that purpose, if nothing else.
Yes.
And that if Mr. Williamson had acted properly, Mr. Brown should not have been there.
Yes. Exactly. And there were some specific fees, costs. By way of example, I mentioned VAT. My solicitor instructed tax counsel, and you can see in the schedule of costs, I won't take you to it, there is a cost for obtaining an opinion from a member of public court tax chambers on whether VAT is liable. So there are specific cost fees, and if you look at the skeleton arguments, you'll see that they are mostly dealing with costs, with fees, for the obvious reason that fees are much greater. The fees were £5,000 odd, and it was only nominal damages of £1,000 sought. So that was where the weight of the work was done, and so there were substantial costs for the fees aspect to be recovered. So I believe that concludes my submissions. I've given reasons why an HCO is a proper respondent to the application. I've explained what the proper cost order should be as a consequence.
And have you also, in the course of those submissions, I think you probably have, dealt with the respondent's notice points?
I have.
Yes.
I've dealt with them. The respondent's notice point comes into my, I think on my third argument about paragraph 66, which Justice Lambert held that paragraph 66 was engaged, but there was no breach of any duty. I said it's paragraph 12 or paragraph 50. The respondent's notice goes to the premise of that argument, which is the HCO a related party? And I've argued that they are a related party because they're the person on whom the enforcement writ names. And I've argued that yes, so in answer to your question, I believe I have.
I see. And ground two?
I believe ground two is just costs. I'm not sure there is a ground two.
I see.
I don't think there's a ground two before the High Court, but
you're not pursuing that.
Yes.
About the
notice of enforcement.
notice.
That's a finding of fact.
Okay. Thank you very much. Yes, thank you very much. Mr. Trivedi, do you want to make a start?
I'm in your lordship's hands.
Yes, well, you might as well if you can lay the ground.
I can certainly do that, my lord. Bear with me. So, my lord, my ladies, the way in which I intend to approach my submissions is simply to take your lordship and your ladyships through the relevant provisions, where I will start from in due course, and I'll use the next 5 minutes just to lay out the groundwork as to how I will approach my submissions after lunch. So what I will do is firstly set out what the respondent's position is in a nutshell. Thereafter, to go through the pertinent background and the pertinent evidence in this case that my learned friend in some instances has not mentioned, which may come to assist in the interpretation of the legislation.
How will the evidence help in interpreting the legislation?
Apologies,
How
my
will
lady.
factual evidence as to what happened on the ground help us in interpreting what the legislation says?
For example, the evidence has shown at first instance that DCBL, the company that appointed, or when I say appoint, the company that instructed Mr. Brown on the ground to go and collect the goods and take his fees, were the ones who were holding the monies. I mean, in actual fact, the evidence in the supplementary bundle shows that the bank account details were those of DCBL. And in actual fact...
That doesn't tell us whether that was right or wrong. If the statute provides that the money should be held by the HCEO, then the fact that it's held by somebody else doesn't really help us on the interpretation, does it?
Well, in due course, what I will say is the High Court Enforcement Officer's regulations, they're a separate species of legislation that doesn't apply to enforcement agents. It only applies to a High Court Enforcement Officer when he himself is enforcing the writ under a different regime, not under Schedule 12. So that's the position I will be raising. But more pertinent to that is the Taking Control of Goods National Standards, which is referred to by the High Court Enforcement Officers Association in their witness statement, actually makes a specific reference. It's worth actually mentioning at this stage, whilst my lady is interested in the point. I don't know if your lordship should have that in front of you. Excellent. It's paragraph 34.
I'm sorry, has this been handed up separately?
It is a separate document, yes. It's mentioned within the witness statement of the High Court Enforcement Officers Association, but it was unfortunately missed out in the authorities bundle.
This came electronically this morning,
Yeah,
but I'm
it
afraid
was
I
in
didn't
this
have a chance to print it out, so I don't know whether...
No, there's a hard copy on my bench.
Oh,
It's a publicly available document, my lord, so there's no issue there in terms of using it.
do you have a...
I do have a spare copy.
I think it's issued by the Ministry of Justice. I can see from the top left-hand corner of this page.
Looks as if my lord has missed out on a copy.
don't think I've got... It's coming
That's
now.
all right.
Oh, thank you very much.
And your lordship will note it's on page, or paragraph 34. That's the paragraph. So here we have a document, as Laing currently mentions. It's by the Ministry of Justice. It's a national standard, so it's guidance to enforcement agents. And you'll see at the top of that particular provision, the title. It's the statutory or financial requirements for enforcement agencies. And it says at paragraph 34 that a separate account for monies due to the creditor should be maintained and accurate books and accounts should be kept and made available to establish monies owed to the creditor. Now, and I'll address this after lunch in more detail, that Schedule 12 doesn't necessarily, compared to the High Court Enforcement Officers regulation that is, Schedule 12 doesn't tell one where the money should go. But we have national standards document specifically directed to an enforcement agency which says that the account for money should be held or should be open and maintained by the enforcement agency. So to the extent
Are you saying that these standards, these Ministry of Justice standards, apply to the agent that has been instructed by the HCEO?
Yes. Now, I want to be very clear because obviously I will talk about the relationship between the two entities and and the separation of their powers as well.
Sorry to interrupt, Mr. Trevedi, but paragraph 3 of this document says
Yes.
that it isn't legally binding. It's a helpful tool to the industry and for creditors.
It isn't legally binding. I appreciate
Well,
that.
there's
my
a more
lady.
fundamental point. If you look under the terms used, enforcement agent is defined as someone who is responsible for the enforcement of court orders against goods, including bailiffs and High Court enforcement officers. On a superficial reading of that, this applies to HCEOs and not to the people that they engage.
I appreciate that, my lady. However, what I would say is, why would there be a provision within a national guidance where if it was absolutely clear on the basis of the regulations that a High Court enforcement officer is to maintain a bank account? And pertinent to that point is the fact that the enforcement agency is the business that employs enforcement agents. And in this case, DCBL appointed Mr. Brown.
Well, that's an entirely new concept in these proceedings. Where does one find the concept of an enforcement agency?
We don't, it's within the national standards, but it points towards the direction of my argument that a High Court enforcement agency, a High Court enforcement officer may maintain a bank account for the purposes of taking the monies from their enforcement of a writ if they were able to do so under a separate species of legislation. But where an enforcement agent undertakes their Schedule 12 powers to go and take control of goods and sell them, then we clearly have in a situation where they are engaged, as in most instances they will be, engaged by an enforcement agency that they work under, the monies will go into a separate bank account. So it actually lends the support to the argument where Schedule 12 doesn't tell one where the money should go. We do have some national guidance which does tell one where the money should go.
Well, I don't think it does, with respect. The national guidance, as I read it, says the HCEO has to have a separate account for monies due to the creditor. But it doesn't regulate enforcement agents in the sense of the somebody who is being appointed by a High Court enforcement officer. It does introduce a concept of an enforcement agency, which is a business that employs enforcement agents, which includes certain public sector organisations that have in-house enforcement agents. But the term enforcement agent, as defined in the national guidance, does not extend to the sub-agent.
What I can say is I appreciate that it does define enforcement agents as potentially including the High Court enforcement officer, but it also includes an enforcement agent. To the extent that it does include an enforcement agent, it tells one where one should keep those monies in these national standards. Whereas under the High Court enforcement officer's regulation, that makes it very clear where the High Court enforcement officer should keep those monies. For a reason which I'll come on to, they are separate entities, and one operates under a different regime for different purposes than the other. So it lends support to that argument, at least. And we also have the evidence in this case that DCBL was the one that held the monies. The enforcement agent, Mr. Brown, directed DCBL to release the monies, and the bank account details are those of DCBL.
DCBL regulated in any way by anybody?
I can't answer that question off the top of my head, my lord. They must be a regulated organisation running a number of different enforcement agents under their regime. But I would.
What if it goes bankrupt when these money's in its account?
Yeah. Or somebody runs off with them.
Or they've got debt, or they've.
Well, in which case, what I would submit is the enforcement agent the enforcement agent that took the goods and sold them, put them into that account, would be the one liable for the liable in some way, shape, or form in that respect. Or you would bring proceedings against DCBL, which actually, in this case, DCBL was one of the respondents at first instance. They were added in as well.
Yes.
So that might be the answer, my lord.
Thank you very much. Well, is that a convenient moment? Sorry, you didn't get very far in your laying out the ground, but
That's why, my lord, I appreciate.
Are you happy to resume now at 2 o'clock? Thank you very much.